over the past 2 weeks, we've been talking about these laws that are being passed, Texas, Tennessee, Idaho, and maybe other places at this point, where they're empowering vigilantes, essentially, through the civil courts to sue people who get abortions and people who aid in that abortion. This is all going to withstand Supreme Court scrutiny, and it more or less has in the context of Texas. And then the question is, what are they going to come for next? They may or may not fully repeal Roe v. Wade. They are going to effectively make it impossible to get an abortion in anywhere from 10 to 20, maybe 20, 22 states in this country. They are going to maybe successfully make it practically impossible for most women to get an abortion if you are a citizen of that state or a resident of that state. You can be sued. You cannot leave the state to go get an abortion. What are they going to come for next? If you think this is about abortion as opposed to controlling women's sexuality, I don't know how else
and freedom and self-determination.
And freedom and self-determination.
Life
and everything
outside
that's
of the home that's not at the behest of a man.
And if this is not ultimately about just maintaining the patriarchy and the essentially the Christian fundamentalist vision of what a family and a home should be, you are greatly mistaken. And here is Marsha Blackburn. And we said this the other day.
Yeah, this has been what you said. I mean, they're going to come for birth control next. And here she is talking about Griswold v. Connecticut, which was a Supreme Court decision that basically allowed, was it married couples to get contraceptives at that time, but then it was expanded.
Yep.
So wide acceptance of contraceptives.
Here is Marsha Blackburn. This is where it starts. She's not some, backbencher in a state legislature in Idaho.
She's a senator.
She's a senator.
Judge who can't say how or if she will apply the Constitution in her rulings is up for a seat on the Supreme Court. Over the past few weeks, I've heard a lot of liberal activists argue that this shouldn't matter. When they look at the Supreme Court, all they see is a rubber stamp for their cultural agenda. The idea a biased policymaker justice appeals to them because they prioritize results over reasoning. After all, choosing heroes and villains is much easier when all you care about is getting the result you want. The chaos that ensues when the court abandons the Constitution and kicks at moving goalposts doesn't really matter to them, but it should. Constitutionally unsound rulings like Griswold versus Connecticut, Kelo versus City of New London, and NFIB versus Sebelius confuse Tennesseans and left Congress wondering who gave the court permission to bypass our system of checks and balances. It is the 11th hour, and where Judge Jackson stands on the Constitution remains a secret. Will she apply its principles as written, or does she wrongly believe that the Constitution is a so-called living document?
Okay, let's. We don't need to hear any more from here, but it's just fascinating that she's bringing up Griswold. The other two that she brought up, NFIB versus Sebelius, was essentially the Obamacare case.
Yeah, what was the middle one that she said?
The second one she said was Kelo versus New London. And this was a case where there was the city of New London was involved in a taking of property I think it was for Pfizer. To build some type of like a factory or something there, with the idea that they would be getting tax revenue from Pfizer, so that this was a legitimate taking. I happen to agree that case, I don't feel comfortable so much with that case. I don't know that tax revenue in that instance it justifies the taking of property because it's
Right.
inevitably going to be also poor people's property. I knew the lawyer. I went to college with I think one of the lawyers involved in that case. But the bottom line is, and then of course Griswold. When was the last time you heard anybody talk about Griswold? And we should say, she mentioned 2 cases that took place in the last 20 years, and then one that doesn't take that is
65.
Yeah, I think
right?
it was. I think Griswold was even before then.
Yeah, no,
65?
Yeah.
Okay, so 60
it was
years.
it was like the last time I really heard about Griswold in any way is it's like that's the precursor to Roe, because Roe comes 2 years later, and then the court was just taking on some of these cases and ruling in the right way. But
And the fact that she's going after Griswold, not Roe v. Wade, because she's already got that in her back pocket.
oh yeah,
Now we're going for the next. There it is.
I mean, it's a frightening little section of a speech because that's clearly, thought of with her like legal team and stuff like that. Like, we're going to mention this specific stuff.
Oh, yeah. And it's not her legal team, right? It's the Heritage Foundation. It's the Federalist Society. I mean, that is the blueprint of where they're going. You begin to introduce it into the lexicon. You begin to actually just sort of like mainstream the idea that standard conservative thought is that Griswold was judicial activism. The idea that you could have birth control.
oh, they're coming for the morning after pill. That's like 2 years out. I mean, like that we're a few months away, to a year away, 2 years away. And like what's crazy too is I feel like there's been very little reckoning with the fact that we're at the crest of this. Like this started with Hobby Lobby and all that stuff when they were targeting I mean, abortion is a separate thing, but this is a part of it as well. Like the right for a private entity to say that our sincerely held religious beliefs as a corporation does not allow us to provide birth control in our health coverage for our employees. Like these are all branches from the same tree, and they are taking a multi-pronged approach to controlling women. And so, this kind of stuff terrifies me. I mean, birth control is such an important way for women to maintain their independence and their, not even self-determination, but just their ability to exist in society in it's somewhat of an equal manner. And that going after that's scary. It's really scary.
That's it. I mean, there's the agenda. I mean, that's and you're going to really see it. You're going to really see it as it comes. And it is essentially open field. It's open running now. They just see the end zone. They've got 6 members of that court. They don't need all 6.
Let's hope
John Roberts is going to be the one who provides like the 4th vote on a bunch of these, so that he can so that really
there's a bipartisan people on the minority too.
The idea is that Roberts knows, and you could look at it right now in terms of like, who was on the Warren court? I don't know, but I know who the Chief Justice was. Name for me who was on the Rehnquist court. That was only 10 years ago. I can name some actually, but but the point stands. The Berger court. These eras are defined in terms of history by the Chief Justice. And so if you have a bunch of rulings that are 6-3, it's going to look worse than if you have 5-4. It looks at least like this has been really contemplated, and it moved. It puts the veneer of more thought and debate moving forward.
of judiciousness, if you will.
But this is where it's going.
Judicious the stacked deck is.